Do you know in a property deal, your entire case depends upon just one thing, your agreement. If your agreement is strong, your case is strong. If your agreement is weak, your money is at risk. Hello everyone, welcome back to the Legal Explorer. This is Advocate Ramana. So, today I'm going to explain a very important real life legal issue, something that affects lakhs of people in property transaction. So, imagine this. You worked hard your entire life, saved around 10 to 20 lakhs, and paid that money as advance to the buyer. But now the seller is not doing registration. The seller is not returning your money. Now the biggest question arises, is your money gone forever? The answer is no. But everything depends upon one thing, your agreement. Listen carefully. In property laws, in property market, your legal in property law, your legal right and remedies depends entirely on what is mentioned in your agreement. If you are signing blindly, it might goes against you. You may lose money, but your agreement must be properly drafted. You can recover your money. You can even force a seller to complete the deal. How? Let's discuss. See, if the buyer defaults, if the buyer fails to pay on time, the seller can fortify the advance money, but only if a clear fortified clause exists in the agreement. If the seller defaults, if the seller refuses to do registration, the property, the buyer has two main legal remedies. First is recovery of money plus compensation. Next is specific performance. This is very important remedy. Now, what is specific performance? Let's discuss. As an advocate, I'll explain you in the simple terminology. It means the court will force the seller to perform the contract. The seller will legally compelled to register the property in your name. Under the Specific Relief Act, which as amended in 2018, specific performance is now the rule, not an exception. If the buyer is right, the court will enforce the agreement. Here, what is an important condition? To win such a case, the buyer must prove what proof? Readiness and willingness that I have the remaining amount, I am ready to pay. Means you were always ready to pay. You have the financial capacity and you must show the bank statements, fixed deposit proof, loan sanction letters. Just saying is not enough. You must prove it legally. When registration is not possible, if the court finds that registration cannot be completed, then the buyer can claim refund of money, interest, compensation. Okay, next we are talking about the important ground, limitation period, which is very important. You must file your case within 3 years. From when? From the date fixed in the agreement for the performance. Important practical point, in many agreements, no fixed date is mentioned. Open end agreements. In such cases, what to do? You must first send a legal notice. From the date of legal notice, limitation starts. Now I'm going to explain the legal process. If the seller refuses, step 1, send a legal notice through an advocate. Even through an advocate. Second, wait for the response. Third, file a civil suit for specific performance. Or what you can do, recovery of money plus compensation. Common mistake what the people do, and many cases like I have seen in my personal life, entering property deals without a proper agreement. Mistakes people make. Okay, trust, signing sellers draft blindly, giving money without written agreement, and the risk what they face in the future, terms may be against you, difficult to prove in the court, money may be get stuck. So in property deals, don't rely or on trust, don't rely on the property agreements. Common mistakes now, and clearly defining earnest money means what? Bayana. Okay, this bayana amount can be fortified. Okay, so the terms must be clear. Okay, the fortified clause must be there. No refund rules. But in a reality, most sellers use standard agreements in their favor. What buyer must check? What buyer must check? Agreement matches negotiation. Refund rules if deal fails. Timeline for refund. Compensation clause. What is written in the agreement is what court will follow. And cash payments without proof, it is a blunder mistake. Paying in the cash, no receipt. If you're paying in the cash, take receipt, no written proof. Risk, it is difficult to prove in the court of law, no transaction record, high chance of losing your hard-earned money. Now, what is the correct way to approach? Use bank transfer, online payment, always take receipt, maintain written proof. In law, only that money is safe which can be proved. And I want to discuss the Supreme Court judgment. In Supreme Court, in the case, it said that Satish Batra versus Sudhir Rawat 2012, court said that seller can only fortify earnest money, nothing but bayana, that too reasonable amount, cannot fortify advance payment. So the advance payment is nothing but part payment. Bayana is nothing but confirmation amount. If the buyer is at fault, okay, agreement must have the clear fortified clause. If no clause, seller cannot fortify the money. Without clear agreement terms, no money can be legally fortified. Finally, what you need to check before signing? Before any property deal, verify title documents, read agreements carefully, consult an experienced lawyer. Agreement must include clear terms, payment structure, refund conditions, fortified clause, compensation clause, buyer rights, specific performance registration rights, refund plus interest plus compensation rules. So I want to conclude this video. I want to give a final message to the viewers. In property matters, your agreement is your biggest protection. One mistake here can lose your lakhs and years in courts. If you want to understand how to recover your money legally, how to draft a strong agreement, how to avoid legal mistake, comment in the comment section. I will help you, I will guide you, or WhatsApp, or you can text in my you can WhatsApp on my number 9550010531. I will help you out. I will tell you how to draft an agreement. Even you can learn. You can just comment, or you can just ping me at my WhatsApp number 9550010531.